Thank you very much for attending today and welcome to our presentation on aluminium composite cladding. My name is Anthony Herron and I am a special counsel at Herron, which is a construction and engineering law firm based in Sydney. This is part 3 of a series of podcasts that provide an update on developments in the law in relation to aluminium composite cladding. So I think the other thing too that's come out of the more recent developments in New South Wales, for example, in October 2019, the state government introduced the piece of legislation called the Design and Building Practitioners Bill 2019. It was released for public consultation. There was roughly a 2-week period of consultation between the 2nd and 16th of October 2019. So it did not give much time for stakeholder comment and feedback. Nevertheless, the government has not rushed in introducing any supporting regulations to that. Secondly, has indicated that it will allow more time to consider these particular issues. And I'd suggest that some of the sort of issues that we should consider in our discussion today, having relevance to cladding, will be about the bill, which will be as follows. What the bill does seek to do is it provides a system of discussion with regulation of particular building experts. So what it does do is provide a scheme for practitioners who prepare regulated designs will issue a compliance declaration, and they must declare that those designs comply with the Building Code of Australia. Now, when we talk about design practitioners, that includes most likely engineers, architects, and those people that are responsible for the design of the building elements. So you would probably capture architects and engineers in that process. You would also have a provision in the legislation for building practitioners. Now, they come under the glare of the bill because they will also be required to be registered. They will also be required to prepare a declaration that the work they do will comply with the Building Code of Australia. And the Design and Building Practitioners Bill does expand the scope of what is regarded as building work. So picking up where the Home Building Act applies in New South Wales, building work is defined there, but it will also include your building elements. It will also include, under the Practitioners Bill, the design and supply of particular building products. So what it does do, the Practitioners Bill expands a system of registration for parties that are responsible for the design of building elements. Also include a system for the registration of those practitioners, so builders and design practitioners. Also include a requirement that any variations to declared designs are prepared and declared by a design practitioner if they relate to a building element or performance solution. So what you have is, for example, a design practitioner involved in the design of a project. If there's any variations to the design, that practitioner must prepare a variation which declares that those comply with the Building Code of Australia. Also, the design or principal design or building practitioner who intends on making a compliance declaration will be registered under a new registration scheme. So what that does is expands those entities that might be caught up as being potential parties who may be responsible to homeowners and owners of land. who are defined in the Design and Building Practitioners Bill. Will also include parties who are responsible for the supply and the design of building products. So, for example, it may include or will include people who supply aluminium composite cladding. The whole idea is it creates this expanded regime of potential defendants against whom homeowners of land or owners, corporations or owners may have recourse to in the event that they discover that there's a defect. Now, importantly, the bill provides for a common law duty of care. So it provides for a common law duty of care for parties responsible for a defect which has resulted in economic loss. So in other words, you're talking about something which has resulted in a failure to comply with the BCA, either at the building or the design stage, and that has resulted in a loss to the owner's corporation or the actual owner. That duty of care is a common law duty. Now, what it does do is it does create potential or further avenues of recovery to owners, corporations and owners of land. So we're talking about not only residential building, but commercial premises as well. So just dealing with the residential space, at the present time, if in New South Wales a person is owner of land, they discover that there's a building defect, they have potential course of action against the builder and or the developer. They have a claim under the Home Building Act, and that means that they are entitled to have a claim for breach of statutory warranties under Section 18B of the Home Building Act. It means that they have their recourse. Now, however, they do not have, at the present time, a claim for common law damages. And that is because the decision of Brookfield Multiplex versus Strata Plan 61288 makes that clear. So in other words, if you have a residential homeowner that has a building defect, provided it's brought within time of the statutory warranties, they have a course of action. They don't have a common law right. So, on the other hand, this Design and Building Practitioners Bill does provide a common law course of action for arising from defects associated with design, non-compliance with the various code of Australia, so against the builder and the designer. I have to say to you that the legislation isn't clear about what the common law course of action might be, but I could see, for example, there might be potential causes of action against architects and or certifiers and or manufacturers or suppliers of defective building product. For example, aluminium composite cladding, which is found to be, at the relevant time, non-compliant with the Building Code of Australia. So that's the first thing. The second thing is what the legislation does provide for is needs to provide some clarity, I should say, in relation to limitation periods. So at present time, the limitation period for breach of bringing actions is 2 and 6 years based on the Home Building Act. What I think there needs to be done needs to be a standardisation of the limitation period. Under the Environmental Planning and Assessment Act, the limitation period for bringing a claim for a building claim is presently 10 years from the date of completion of the work. So in essence, you've got different limitation periods. For defective work, you've got 2 and 6 years, relatively, respectively, under the Home Building Act. Under the Environmental Planning and Assessment Act, you have 10 years from the date of completion. Common law damages, though, provide for run differently in that, as provided under the bill, the common law course of action will run from the date on which the defect becomes apparent. So in other words, what it does do, it does extend out the potential liability of defendants from not the date of completion of the work, but from when the defect first manifests itself. So those issues are important for practitioners in the area to be alive to when advising their clients about these different rights that apply in relation to the Design and Building Practitioners Bill. There's also an issue dealing with the differing standards of care. Now, in its submission to the government on the Design and Building Practitioners Bill, Architects Australia has raised several what I think are valid points regarding the different standards of care. For example, of a building practitioner who must take all reasonable steps to ensure that they will comply with the Building Code of Australia, as opposed to design practitioners who the bill refers to seems to have a higher duty in that they must ensure design compliance. They must ensure that where variations to declared designs are prepared, that they will comply with the Building Code of Australia. That seems to me to create a higher standard of care for design practitioners as opposed to building practitioners. I suggest that's something which should be addressed in any clarification of the regulations to the Act, that is the incoming Design and Building Practitioners Act. I think there's a third issue needs to be clarified is the issue of proportionate liability. Proportionate liability talks about how you apportion or share liability between different defendants. The Design and Building Practitioners Bill makes a provision for there to be no contracting out. I think that probably needs to be clarified to ensure that there will be no contracting out. And so in other words, it's not possible for a defendant to so prepare a contract so that it will be able to avoid liability completely under the legislation. That would sort of go against the very idea of introducing some liability of designers and design practitioners being potentially sharing liability if they could otherwise avoid liability under the Act. What I'll think the fourth issue that's important is to clarify under the bill is this issue of having suitably qualified experts. Now, this is ever more so the case where you're seeking to identify what are the origin and the cause of building defects. And that's always important to have a suitably qualified expert to make a comment regarding those particular issues. I'd also suggest that there needs to be a conversation with insurers in terms of identifying, as based in section 29 of the Design and Building Practitioners Bill, those sort of issues which might arise concerning the future regulations regarding insurance requirements, such issues as indemnity, who can provide the insurance, the risk, the amount, the obligations on the persons providing the indemnity, and how long those indemnity periods should last. At present, it doesn't seem to me that there are adequate or any insurance products on the market which would seem to address those particular areas of risk which are provided for in the Design and Building Practitioners Bill. I'd suggest that that is something which should be clarified with various stakeholders and the government in terms of further amendments to the bill. I think those are important issues which will give clarity to understanding more about the effect of the Design and Building Practitioners Bill, and then to understand how the insurance works with it, understanding that insurance is important to protect risk. And without adequate insurance, that would only lead to design practitioners and or experts, professionals in the area, not being able to carry on business effectively being uninsured. The last slide we'll deal with, just to wrap up today, how can we assist our clients? In our discussions today, we've focused on particular areas which have related to the difficulties faced by policymakers when considering how you actually provide a system of regulation to both safeguard the homeowner, which is the first and important element of the Building Code of Australia, so safeguard the occupant. And then secondly, to minimise fire spread. As we've seen from the cases which we've discussed, the failure in Grenfell was, and the loss of life, was due to one use of a product which was clearly in breach of the regulations in the United Kingdom as applied in Grenfell. Secondly, as shown in the La Crosse decision, the fire resulted from, again, breaches of the Building Code of Australia. And so what sort of things should we be advising our client? Well, firstly, we shouldn't panic to think that just because a building is covered with aluminium composite cladding, that it will result in a fire in every case, or that is of enormous risk. It is always important to consider the risk and then advise action based on an assessment of what the risk poses. So if you have a fire safety risk, it's important always to engage a fire protection specialist. The first I would suggest would be a A1 accredited certified or a C10 fire safety engineer. They are members of industry bodies such as the Fire Protection Association of Australia, the National Fire Industry Association, or Engineers Australia. And you can obtain details of the relevant qualifications and accreditation of experts through accessing the Building Professionals Board website, which is listed on this particular slide. Now, the way that that expert would make an assessment would be to review the design and construction documents. So in other words, to understand whether the external wall cladding was made of aluminium composite panels, and then the scope of the services that were provided by the relevant professionals at the time, leading to the contract before work started, and then to understand the contractual obligations. So those sort of things are important for the expert to consider. Practically, an owner's corporation or a building owner should actively consider whether they are at commercial and or residential premises, whether the building's fire safety statement is up to date. If it is up to date, that will last for a current for 12 months. Those sort of things are very important to satisfy the building's insurance requirements itself, and also ensure that there is occupant safety. So those are practical issues from a fire safety perspective, which I think are important to be addressed on an annual basis. And then, of course, the particular issues we've discussed concerning briefing an expert, they should prepare a report. If there is a letter or a fire order from the relevant council that the building should be investigated, then those experts are ideally placed to review those documents and then provide their commentary regarding the nature of the cladding, whether it does comply with the building safety ban and the Building Code of Australia, and then if it does, then provide an action plan for the removal of the cladding, either wholly or partly, or some other action plan, so that both the owners corporation and the owners and the local council can be satisfied that the requisite processes have been followed. The final thing I think is, I think we might have touched on some of these before, but I think they are worth considering again. It's always important to understand when you're advising a particular professional, say design space, what their own insurance requirements are. So firstly, they should have adequate professional indemnity insurance. If you're acting for that particular professional, such as an architect or a design consultant or an engineer, fire safety engineer, always seek, if you can, in the negotiations with, say, a builder or a principal, to try to place a cap, a monetary cap on their own liability for obvious reasons as set out across. On the other hand, if you are advising a principal and or a constructor, you should be trying to ensure that there is at least a cap on their liability at all, for the obvious reasons as shown across, because as seen there, you may have a fee estimate of several $100,000 or even less, yet your potential liability as a design professional may exceed that many, many times. So consider the professional indemnity insurance. Discuss the matter with your broker if you're uncertain. Understand what exclusion clauses might apply in relation to building products and materials. Understand what disclosure requirements you have as a professional to both your insurer and as a professional, also understand what your contract requires you to do. I think we might have discussed this in the Lacrosse decision, but I think it's worth repeating. Part of the reason that Judge Woodward in the Lacrosse initial judgment found that there was liability against the fire safety engineer and the architect was that they, particularly the engineer, had failed to really come to terms with the terms of their own contract. They used template documents that they thought covered their own risk. Judge Woodward had some important things to say about that and said that those template or boilerplate clauses which a party thinks should apply and will cover them, in other words, effectively cover their risk, need to be revisited every contract. The reason being that just using a standard clause for one contract means that, or may not mean that, that will provide adequate cover against the risk of liability for the next project. So that was the judge's comment. Match the insurance risk and with the contract exposure and include that in the contract itself. Understand the scope of services, include that, and then meet the contract. In other words, ensure that the contract obligations are designed to match the professional consultant's obligations as well. And practically speaking, don't be afraid to speak up. So in other words, if we're advising our principals or our consultants, that if there is a problem and they observe that either before the contract starts, in other words, before the building work starts, and they are reviewing design documents and or building materials and specifications, and they realise that there's a problem, in other words, that they do not comply with the Building Code of Australia, for example, they should advise the owner and a principal. Staying silent will not assist the consultant case if there be something, or should there be something go wrong. So I think those are important issues, and I think also trying to address those issues head on, so that if you, for example, see that there's a particular product specification, you check that in the manufacturer's spec and understand that that spec is inconsistent with, in other words, doesn't comply with the Building Code of Australia. That's the time to seek an amendment to that to ensure that a product is designed and or supplied which complies with the Building Code of Australia. Just finally, I don't think we're likely to see the end of the particular issues with cladding. Cladding is just but one part of what we call the ongoing need by the regulators to address issues with building defects, to ensure that we have both the safety of the occupants and also to minimise fire spread. The changes in terms of the legislation, the Building Practitioners Bill, in December last year, I think is a welcome change. Will be interesting to see how that plays out in the next 6 months or so. The Public Committee for Public Accountability Committee in the New South Wales Parliament introduced a bill in late December where they commented regarding the Design Building Practitioners Bill. They are urging the government to ensure as quickly as possible, that is, they're suggesting that by March 2020, which is not very long away now, this bill should be introduced as a piece of legislation. Secondly, the insurance industry needs to be involved to ensure that there be adequate insurance products in place to provide certainty to design and building practitioners that they can be covered for their risk in attending and doing this particular work. There's also, I think, the need for the government to actively consider introducing the recommendations made from the 2015 report of Michael Lambert concerning regulation, and so that was part of the commentary recommendation from the New South Wales Public Accountability Committee in December 2019. All of those mean that this area of defects, liability, and understanding the use of using building products that are safe, that are compatible with a safe environment in which people live, I think is important. Thank you. Thank you for listening to our podcast. This concludes our series on aluminium composite cladding. If you would like some information in relation to this topic, please visit the articles on our website and also download our ebook on cladding updates. We look forward to connecting with you in our next podcast. Should you require any assistance, please contact us.